Welcome to the Tailor Law Podcast, where we provide trusted legal insights to help you navigate the complexities of family and divorce law in Ontario. I'm your host, Deepa Taylor, and today we're discussing a critical and often misunderstood topic: how to manage bankruptcy during a marital breakdown in Ontario. This episode is packed with essential information for anyone facing the dual challenges of separation or divorce alongside financial distress. If you're dealing with these difficult circumstances, you're not alone, and we're here to guide you through it. So, let's get started. A marital breakdown is emotionally and financially taxing. Add bankruptcy into the equation, and the situation can become even more overwhelming. Understanding how bankruptcy interacts with family law in Ontario is crucial to protecting your rights and making informed decisions. In this episode, we'll explore the legal landscape surrounding bankruptcy during separation or divorce, how it affects property division, support payments, and what options are available to manage debt responsibly. First, let's clarify what bankruptcy means. Bankruptcy is a legal process where individuals who cannot pay their debts can eliminate most of those debts and start fresh. In Canada, bankruptcy is governed by the Bankruptcy and Insolvency Act, a federal law that outlines how debts are handled and what assets can be protected. When a couple separates, they must divide their assets and debts fairly under Ontario's Family Law Act. However, bankruptcy can complicate this process. Many people believe that spouses automatically share responsibility for each other's debts, but that's not always true. Only debts that are jointly held make both parties liable. For example, if both spouses co-signed a loan or a credit card, they are both responsible for that debt. But if the debt is solely in one spouse's name, the other spouse isn't legally obligated to pay it. Now, let's talk about equalization of property. In Ontario, the Family Law Act requires spouses to calculate their net family property, NFP, to determine if one spouse owes the other an equalization payment. This process becomes complex when bankruptcy is involved because the bankrupt spouse's assets vest in a licensed insolvency trustee who manages the distribution of assets to creditors. The timing of bankruptcy, whether it occurs before or after separation, can significantly impact the equalization process. If a spouse files for bankruptcy before separation, their assets become part of the bankruptcy estate, potentially leaving little for equalization. Conversely, if bankruptcy occurs after separation, but before property division is finalized, the equalization claim becomes an unsecured debt in the bankruptcy. This means the non-bankrupt spouse may have to line up with other creditors to collect what they are owed, and they may not receive the full amount. But what about the matrimonial home? In Ontario, the matrimonial home has special protections. Both spouses have an equal right to possess the home, regardless of whose name is on the title. However, if one spouse declares bankruptcy and they jointly own the home, the bankrupt spouse's share of the home becomes an asset of the bankruptcy estate. The licensed insolvency trustee may force the sale of the home to satisfy creditors unless the non-bankrupt spouse can buy out the bankrupt spouse's share. Another important aspect to consider is support obligations. Child and spousal support payments are not discharged in bankruptcy. This means that a spouse who declares bankruptcy must continue to pay any court-ordered support. Additionally, any arrears in child or spousal support from the 12 months before the bankruptcy filing are considered priority debts. This ensures that support payments remain protected despite the bankruptcy. You might be wondering about alternatives to bankruptcy, like consumer proposals. A consumer proposal is a formal agreement between a debtor and their creditors to pay back a portion of their debts over a longer period, typically up to 5 years. This can be a more manageable option for some individuals, allowing them to avoid bankruptcy while still addressing their financial obligations. Unlike bankruptcy, a consumer proposal doesn't automatically affect the division of property in a separation. One common misconception is that one spouse's bankruptcy automatically affects the other spouse's credit. This is not true unless the debts are jointly held. If the bankrupt spouse had individual debts, the non-bankrupt spouse's credit remains unaffected. However, it's essential to carefully review and separate any joint financial obligations to prevent unintended consequences. So, What steps can you take if you or your spouse are facing bankruptcy during a separation? First, seek legal advice. Consulting a family lawyer and a licensed insolvency trustee can help you understand your rights and obligations. These professionals can guide you through how bankruptcy might impact your family law matters, including property division and support payments. Second, prioritize communication and transparency. Disclose all financial information honestly to your spouse and legal representatives. Hiding assets or debts can lead to legal complications and even court penalties. Third, consider negotiating a separation agreement that accounts for debt management. This can include clauses about how joint debts will be handled and how assets will be divided, potentially preventing disputes down the road. Finally, understand your options. Whether it's bankruptcy, a consumer proposal, or other debt management strategies, knowing what's available can empower you to make informed decisions that protect your financial future. Navigating bankruptcy during a marital breakdown is undoubtedly challenging, but you're not alone. At Tailor Law, we specialize in family and divorce law and understand how financial difficulties intersect with separation and divorce. Our experienced legal team can help you explore your options and develop a strategy that safeguards your interests. If you're struggling with debt and facing a separation, visit tailorlaw.com to schedule a consultation. We're here to provide the legal guidance you need to move forward with confidence. Thank you for joining us on the Tailor Law Podcast. If you found this episode helpful, please subscribe and leave a review. And remember, for trusted legal advice on family and divorce matters in Ontario, visit tailorlaw.com. Until next time, take care.